I rise today to present House Joint Resolution Constitutional Amendment 28. House Joint Resolution Constitutional Amendment 28 proposes to make a change to our state constitution that we are quite familiar with, but one we cannot overlook because it is language that has proven truly to be transformative. The Federal Voting Rights Act of 1965 and its 1982 amendment took historic steps to secure ballot access, enfranchise historically marginalized groups, and combat discriminatory practices most commonly exercised by Southern states. Consider this. Before the Voting Rights Act, Black representation in Congress consisted of 5 members. 5. And towns across the country were racially gerrymandered in such a way that there was no minority representation on school boards, city councils, and in state legislatures. The Voting Rights Act of 1965, the 1982 amendment, and case law interpreting its provisions for over half a century increased that number 12-fold, and today's 118th Congress is the most racially diverse in our country's history. But we saw in 2012 the first attack by an extraordinarily partisan U.S. Supreme Court when it gutted the pre-clearance requirements. Now we find ourselves in a familiar situation. Our current and even more radical U.S. Supreme Court is considering gutting Section 2 of the Voting Rights Act completely. It is undeniable that the U.S. Supreme Court is poised to dismantle these protections. And when it does, some states will quickly undertake new gerrymandering schemes aimed at stripping away Black and Latino and other minority representation. Here in Illinois, we refuse to go back. We won't go back. Put simply, House Joint Resolution Constitutional Amendment 28 ensures that no citizen on account of race is denied the opportunity to elect representatives of their choosing. And it takes steps to ensure Illinois voices are not silenced, no matter what Washington says. I ask for an aye vote of this initiative, Mr. Speaker, and welcome any questions.